Hello everyone! Well, I hope you're feeling fresh and fine. Sana nakapag-relax yung isip nyo, yung utak nyo ngayon dahil today we will be discussing, medyo mahaba-haba talaga to. We will be discussing the essential requisites of contracts. So, dahil nga medyo mahaba, expect na meron talagang provisions na hindi tayo magdi-dwell ng matagal, especially if madali lang siya, okay? And then, para at least hindi naman masyadong dragging yung discussion. And then, ano pa ba? Expect rin na I will not be reading each provisions. Siguro, post nyo na lang basahin yung baka mas mabilis kayong magbasa kaysa sa akin. Kasi mas maganda rin naman na habang nakikinig kayo, may hawak-hawak kayong mga provisions or libro or notes niyo dyan para makapag-take note. Mas mabisa ata pag ganun. So, ano pa bang inaantay natin? Let's begin! So, Article 1318. Obviously, first and foremost, i-discuss natin ano ba ang requisites ng isang kontrata. Okay? Sabi nga, the essential elements or requisites which without this, etong tatlo, there can be no contract. So, at least memorize nyo na. Madali lang siyang i-memorize. Consent, object, cost, COC. First, consent of the contracting parties. Second, object certain, which is the subject matter of the contract. And third, cause of the obligation, which is established. Okay? So, memorize nyo na rin. Mas madali siya. Anyway, we will be discussing each. Ito talaga yung di-discuss natin in this video, yung ano ba ibig sabihin ng pag sinabi ng consent of the contracting parties. Tapos yung object certain, okay? Which is the subject matter nga ng contract. Tapos yung cause of the obligation, tapos sabi which is established. Now, these elements are subdivided into common and special elements. Pag sinabi mong common elements, ito nga yung present in all contracts, okay? Such as consent, object, and cause. Yan tatlo talaga. Pero meron din tayong tinatawag na special elements, which are present only in certain contracts. Example, if it is a real contracts, then dapat meron pang-apat na elements doon. And alam nyo na, that is delivery. And then, if yung contract naman is a solemn contracts or yung formal contracts, meron ding additional pero special elements din, di ba? And that is, yes, kailangan ng compliance with the formalities required by law. At palagi ko nga example, pabalik-balik na is yung donation inter vivos. Okay? So, that's it. That's Article 1318. Proceed na tayo kay 1319 and simulan na nating i-dissect si consent. Ano ba ang ibig sabihin sa batas pag sinabi mong consent? Article 1319, particularly yung first sentence, defined consent as, sabi, consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause by which are to constitute the contract. Tapos, dinefine pa nga ulit kung si offer daw, it must be certain and the acceptance absolute. Yan. Tandaan nyo yan. Offer must be certain, tapos yung acceptance must be absolute. Anyway, i-discuss natin siya later para mas, klaro. So, yon. Consent is defined as the meeting of the minds between the parties with respect to the subject matter and the cause of the contract. Diba? So, if Pogi offered to sell his car to Ganda for, say, 1 million pesos, tapos hindi pa nagko-consent si Ganda na bibilhin niya yung car ni Pogi, and then, nag-withdraw na siya sa offer niya, ayaw niya na daw ibenta. So, question, was Pogi allowed to do so? Pwede niya bang i-withdraw ang kanyang offer to sell his car for 1 million pesos? Of course. Bakit? Kasi wala pa naman perfection of contract. Kasi wala pang consent, wala pang meeting of minds between the parties. Hindi pa tinatanggap ni ganda, right? And so, pwede pa talagang umatras si Pogi sa kanyang offer. Now, eto. What are the requisites of consent? So, ano ba ang kailangan para masabi mong mayroong consent? So, first requisites is there must be 2 or more parties. Malamang, kailangan talaga. Kailangan naman mag-consent ka sa sarili mo, right? Then, second, the parties must be capable or capacitated. Okay? Para magkaroon ka makapagbigay ka ng valid consent, kailangan capable at capacitated ka. Kasi pag hindi, like example, if yung kakontrata mo is baliw, pwede niya bang, di ba, anong ine-expect mo sa consent niya? So, anyway, pag ganon, dahil nga baliw naman yung kausap mo, kahit pa mag-consent yan, huwag kang mag-expect, right? Kasi hindi valid yung consent. Pag walang consent or iba, pag totally walang consent, iba siya. At pag medyo ganun lang, yung hindi lang capable. Anyway, we will be discussing that later. Siguro hindi sa topic na to in our next videos. Pag nag-discuss na tayo ng mga voidables and voids dun sa defective contracts. Now, third requisites, there must be no vitiation of consent. Okay? So, walang dapat fraud, intimidation, or kahit ano pa mang nakaapekto sa consent. It must be voluntarily, intelligently, ganun, binigay si consent. Okay? Fourth, there must be no conflict between what was expressly declared and what was really intended. Of course, dapat pareho yung sinasabi mo sa kung ano talaga yung intention mo para naman magkaintindihan. Okay? Anyway, meron ding ibang remedies naman if ever. Iba pala talaga yung intention nyo, tapos yung nangyari or yung naging nasa kasulatan ay iba, that would be for reformation. Yung remedy nyo dyan is reformation, and we will be discussing that later. Hindi dito sa video na to. In our next videos pa rin. Tapos lastly, last requisites is yung intent must be declared properly. Okay? Kung whatever legal formalities are required, it must be complied with. If consent lang, by mere consent, di okay. Pero kung kailangan ng public document, din dapat nandun din, may public document. So, dun yung consent. Okay? So, that is the requisites of consent. Now, let's proceed with the second sentence ng first paragraph ng Article 1319. Sabi, mahalaga din to, okay? The offer must be certain and the acceptance absolute. So, ano ba ang ibig sabihin pag sinabing offer must be certain? Pag sinabi mong certain, din dapat it must not be obviously vague. It must not be misleading or it must not just be a mere joke, okay? Hindi din siya dapat parang nag-e-express lang ng desire or hope. Dapat the offer must be certain and seriously intended. The offer must be definite so that upon acceptance ng kabilang parties, an agreement can be reached on the whole contract, di ba? Kasi pag yung offer mismo hindi mo alam at inaccept ng kabila, baka ano ba talaga yung offer? Ano ba yung inaccept? So, hindi klaro. So, kailangan certain, definite, para naman if inaccept, nag-agree yung inofferan mo, magkakaroon talaga ng agreement and contract, right? Now, dito naman tayo sa acceptance absolute. So, meaning, hindi qualified, okay? It must be unqualified. Acceptance, absolute talaga, inaccept mo ng buo, walang kondisyon, at hindi counter-offer. Kumbaga, halimbawa, dun sa example natin kanina kay Pogi, inoffer niya kay Ganda ang kanyang sasakyan for 1 million pesos. Dapat yung acceptance ni Ganda ay yes, ganun lang. yes, or yes, I agree, or yes, I accept your offer. Yung mga ganun. Kasi pag sinabi niyang, pwede bang 800,000 pesos lang? Then walang acceptance, di ba? Kasi, nung nag-counter offer, actually, nung sinabi niya, nung may condition, di ba, na 800,000 pesos lang, that is actually a counter offer. And so, it's good like as if na-reject mo yung offer. It's a rejection of the original offer. Right? And so, wala pang meeting of minds. Hindi pa perfected yung contract. Kasi wala pang acceptance na absolute kasi nag-counter offer pa si Ganda. Now, suppose ganito ang nangyari. Etong si Ganda, siya yung pumunta kay Pogi. And then, sabi niya, Pogi, pwede ko bang bilhin ang sasakyan mo ng 800,000 pesos? Suppose si Pogi ay ganito ang sagot. Pwede ba 1 million pesos? Si Ganda ay napaisip, parang hindi niya kaya ang 1 million pesos for that car of Pogi. And so, umalis na siya. Now, if nung paalis na si Ganda, tinawag siya ni Pogi at ang sabi ni Pogi, okay Ganda, I am willing to sell my car for 800,000 pesos. Ang tanong, is Ganda allowed not to buy that car of Pogi? Pwede pa ba siyang umatras? Kasi originally, yun talaga yung offer niya. Ayaw ni Pogi. Now, ngayong ayaw niya, dun sa new offer ni Pogi na 1 million pesos, tinawag siya ni Pogi na okay na 800,000 pesos. So, ang tanong, pwede pa bang umatras si Ganda? O nagkaroon na ng meeting of minds at na-perfect na ang contract kaya hindi na pwede? What do you think? Can you answer it in your mind? And let us check if pareho ba ang sagot natin. Eto, the answer is yes. Pwede pa. Kasi ganito ang nangyari talaga. Nung nag-counter offer si Pogi na ibebenta niya yung kanyang sasakyan for 1 million pesos, he was not accepting the offer of Ganda, di ba? To buy the car for 800,000 pesos. Yung ginawa niya actually was a qualified acceptance. And, di ba, sabi ko kanina, qualified acceptance constitutes a counter offer. So, actually, nung sinabi ni Pogi kay Ganda na ibebenta niya for 1 million pesos, okay, it was a counter offer. And nung umalis si Ganda, tapos sinabi niya ulit, diba, hinabol niya, tinawag niya ulit at sabi niya, okay, I will sell it for 800,000 pesos. Hindi niya actually ina-accept yung original offer ni Ganda to buy that car for 800,000 pesos. What he was doing was actually making another offer. Okay? Another counter offer which kailangan ding i-accept ni Ganda or pwede niyang i-accept or pwede niyang i-reject. Right? Eto siya. A counter offer, as a matter of fact, ganito, extinguishes yung original offer. Okay? So, it may or may not be accepted by the original offeror. In this case, by Ganda. So, wala pang meeting of minds. Wala pang consent from both parties. Kasi the offer, although certain, acceptance is not yet absolute. Wala pang acceptance. Right? It's actually the same rin pag halimbawa may nagbebenta sa inyo tapos tumatawad kayo na pwede bang hulugan, 3 months to pay, 1 or 1 year to pay, mga ganun. That is another offer. Walang acceptance na, okay, bibilhin ko yan, pero pwede bang 3 months to pay or 1 year to pay? So, wala pang acceptance that is absolute. So, no consent. No meeting of minds, no perfection of contract. Now, let's proceed in our discussion. Ano na ba? Saan na ba tayo? Okay, we're done with the first paragraph ng Article 1319. Na-discuss na natin siya. So let's proceed with the second paragraph. So this talks about acceptance through correspondence, di ba? If yung acceptance ay pinadala through a letter or a telegram, actually hindi na masyadong yung telegram, pero yan, through correspondence nga, through letters. So, ang sabi ni Article 1319, acceptance made by letter or telegram does not bind the offerer, except from the time it comes to his knowledge. Okay, so magiging binding lang yung offer ni offeror, okay? Yung offer ni offeror ay magiging binding lang from the time in-accept na yung offer niya and it has come to his knowledge. Malinaw ba sinabi ko? Anyway, ganito. On December 1, halimbawa, on December 1, si Pogi nag-offer siya na ibebenta niya kanyang sasakyan kay Ganda for 1 million pesos by letter. Nagpadala siya ng sulat. And so, etong si Ganda, natanggap niya yung letter and so consented to buy that specific car of Pogi on December 5. So, Ganda wrote a letter of acceptance, of course, and wrapped it at the mailbox on December 10. While the letter is in course of mail, etong si Pogi ay namatay. So, question, is the contract perfected? The answer is no. Yung death ng either parties before the acceptance is actually renders the offer and acceptance ineffective. Diba sabi nga, magiging binding siya pag yung acceptance, which is done through a letter, was or came to his knowledge. Dito, paano niya pa nalaman? Ipatay na nga din siya. So, walang perfection of contract. Walang hindi nabenta yung sasakyan ni Pogi. Okay? Now, let's take another example just to better understand this topic. Supposed in December 5, 2020, Pogi, nagsulat ulit siya kay Ganda. Ino-offer niya for lease ang kanyang bahay. Gusto niyang paupahan kay Ganda ang kanyang bahay. Now, supposed on December 15, 2020, etong si Ganda, nagpadala din siya ng sulat, okay? Completely accepting the offer of Pogi. So, kumbaga, yung acceptance niya is complete and absolute. So, pero, etong letter of acceptance ni Ganda, ito ay natanggap ni Pogi on the following day by December 16, 2020. Pero ito yung, importanteng data. Noong December 15 morning pala, etong si Pogi ay nagsulat na ng letter withdrawing the offer. Okay? Wine-withdraw niya yung offer kay Ganda na papaupahan niya yung kanyang bahay. Hindi alam ni Ganda yon. Hindi alam ni Ganda na withdraw ni Pogi. The following day pa nga, diba, nagpadala siya ng letter of acceptance. Question, was there a contract? The answer is no. Why? Because prior to the receipt of the letter of acceptance, yung offer had already been withdrawn. Okay? Withdraw na ni Pogi bago pa man may acceptance. Di ba sabi, yung acceptance is binding only from the time when the offer came to the knowledge of the offeror. Okay? So, I think that's it. That's Article 1319. Oh, wait, my last sentence pa pala. Sinasabi lang naman, actually, is very self-explanatory. Sabi lang naman, the contract in such a case is presumed to have been entered into in the place where the offer was made. So, kung saan nagawa yung offer, it is presumption lang na doon din nangyari yung contract. Okay? So, let's proceed to Article 1320. Actually, madali lang din naman tong Article 1320. Sinasabi lang na acceptance may be expressed or implied. When you say express, meaning in the form of expressly either written or sinabi mo talaga na okay. Ang Mas medyo challenging is pag implied, meaning babasahin lang natin according to the conduct, the act or conduct nung inoferan mo after. Proceed na tayo kay Article 1321. Ganun lang naman, simple lang yung ibig sabihin ni Article 1320. Si Article 1321 naman, it talks about the things that may be fixed by the offerer. Ito ay yung time, place, and manner of acceptance. So, si offerer ang mag-fix niyan. And then, any act contrary dun sa na-require ni offerer actually constitutes a counter-offer or counter-proposal on the part of the offeree. Okay? So, example, if si Pogi, kung siya yung nag-offer kay Ganda, pwede niyong sabihin dun na acceptance of this offer must be made in writing and dapat matanggap ko on or before December 15. So, ganon. So, kailangan i-comply yon ni Ganda. Okay? So, I think wala nang masyadong controversy dito sa Article 1321. Let's proceed with Article 1322. Article 1322, meron na tayong tatlong parties. Kasi pag binasa mo, an offer made through an agent is accepted by the time acceptance is communicated to him. So, meaning, dito meron tayong offerer, meron tayong, of course, offeree, and meron tayong agent. Actually, agent by legal fiction is considered an extension of the personality of his principal. So, if meron kang inauthorize na person who communicates or made the offer to, halimbawa, if si Pogi, may offer siya to sell his car to Ganda, and the offer was made through Beauty, okay? Inutusan niya si Beauty na mag-offer kay Ganda. Sabi dito ni Article 1322, yung offer daw is considered as accepted from the time yung acceptance was communicated to Beauty. Okay? Yun nga sabi ko kanina, si agent is actually an extension of the personality of the principal. The fact na siya nga yung gumawa ng offer, so pwede na rin naman na sa kanya na rin ipasabi ni Ganda ang kanyang acceptance. Sabihin niya na lang kay Beauty and that's it. There is already an acceptance in that scenario. Pero, meron tayong, klaro lang natin na ito is if si agent mismo ang gumawa ng offer. Okay? Inutusan siya ni principal or ni offeror through an agent, tapos si agent mismo ang gumawa ng offer to that offeree. Pero if ever, ang nag-offer mismo is si principal or si offeror, papunta kay offeree, dapat yung acceptance ay hindi kay agent. Dapat diretso kay offeror. Okay ba? Malinaw. So, I think that's it. That's Article 1322. So, let's proceed with Article 1323. Ito naman, nagdi-discuss kung kailan ba ang offer ay magiging ineffective, mawawalan ng visa. Sabi, mawawalan daw ng visa ang offer from the time of pag may death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. So, if prior to acceptance, namatay, nagkaroon ng civil interdiction, insanity, insolvency. Actually, dito sa term na to, malamang death, insanity, at insolvency ay alam nyo na. Yung civil interdiction lang siguro yung hindi nyo pa alam. Anyway, civil interdiction is an accessory penalty in criminal law. Usually kasi, pag may taong nakagawa ng krimen and is found guilty of that, may mga, although specific crimes, tapos specific penalty na ang accessor, like example, yung sa life imprisonment or sa death penalty, merong kasama yung accessory penalties na civil interdiction. Meaning, mawawalan ka rin ng at some point, mga certain rights lang din. Okay? So, that is civil interdiction. Now, do you think kailangan pa ba natin ng example? Same, pwede na yung example natin kanina na nag-offer si Pogi, tapos prior to the acceptance of Ganda, namatay si Pogi. So, automatic, mawawalan ng visa yung offer ni Pogi. And that is expressly provided under Article 1323. So, walang meeting of minds, di ba? So, let's proceed with Article 1324. Sa Article 1324, if the offerer has allowed the offeree a certain period of time to accept, di ba? Binigyan niya ng certain period like say 30 days to accept the offer. Sabi dito ni Article 1324, yung offer ay pwede namang ma-withdraw anytime before yung acceptance ni offeree. Papaano i-withdraw ang offer? Simple as communicating such withdrawal. Paalam mo lang na you're no longer interested or you're no longer willing to sell, kung to offer to sell yan, or kung ano man ang offer mo originally. Okay? But then, this is not absolute. Meron din siyang exception. Yung sa last phrase, except when the option is founded upon a consideration, something paid or promised. So, yun na nga, meron ding exception pala. So, halimbawa ganito. If si Pogi, in-offer niya na ibenta ang kaniyang lupa at bahay kay Ganda for 1 million pesos, who is actually interested in buying that house of Pogi. Pero sa letter ni Pogi to Ganda, sinabi niya naman na binibigyan niya si Ganda ng a period of 10 days from today. Suppose kung ngayon is November 1, 2020, so binigyan niya si Ganda ng 10 days from today to accept the offer. Now, suppose on November 5, si Pogi ay pumunta sa bahay ni Ganda at withdraw niya na ang kanyang offer. Ayaw niya na. Kumbaga, kinakancel niya na yung offer niya kay Ganda to sell that house for 1 million pesos. Question, can Pogi validly do so? Pwede niya bang i-cancel? Di ba nga, dun sa letter, binigyan niya ng 10 days si Ganda to accept the offer. So, the answer is yes, of course. Kasi mere offer lang naman yon, meaning withdrawable at any time. At ang sabi ko nga kanina, papaano i-withdraw? Kailangan lang i-communicate ni Pogi kay Ganda na he is no longer willing to pursue or just simply says na wini-withdraw niya na yung kanyang offer to sell, diba? Pwede naman yon. That is the rule under Article 1324, pero meron siyang exception. Halimbawa, ganito. Dun sa senaryo nga na sinabi natin kanina, suppose itong si Ganda, nagbigay siya ng pera kay Pogi worth, sabihin na natin, 1,000 pesos as an option money. So, pag yung question is, can Pogi withdraw within the 10-day period? Dito, hindi na. Why? Because the offer is founded on a consideration. Diba? Yun yung sinasabi ng last phrase na except when the option is founded upon a consideration. Dito, nagbayad nga si Ganda ng 1,000 pesos. So, hindi basta-bastang makapag-withdraw si Pogi pending that 10-day period na binigay niya kasi nagbayad si Ganda for that. Naiintindihan nyo? So, under Article 1324, we will encounter the term option contract at saka option money. Option contract, ito yung usapan na binigyan ni Pogi si Ganda ng, dito sa example natin is 10-day period within which to accept the offer, right? Yun is the option contract. Tapos, yung binayad naman ni Ganda to Pogi na 1,000 pesos is what we call option money. Okay? It is the money paid or promised for the option. Okay ba? Malinaw? So, it should not be confused with earnest money. Kasi sa earnest money, that money will constitute or will form part with the yung whole purchase price later on. Parang partial payment yung earnest money. Si option money will not form part of price nung suppose kung later on bibilhin talaga ni Ganda yung bahay ni Pogi, magbabayad talaga siya ng full amount. Iba yung earnest money tsaka option money. Kasi yung option money, payment mo yan for that option. Kaya hindi pwedeng mag-withdraw anytime si Pogi unless tapos na yung 10-day period. At walang acceptance na ginawa si Ganda. Kasi if within that 10-day period, inaccept ni Ganda yung offer ni Pogi, then there is already a meeting of minds. What's there to withdraw if ganon? Hindi na pwedeng mag-withdraw kasi may meeting of minds na. Okay? But before natin iwan si Article 1324, before tayo mag-proceed to Article 1325, eto lang. Please note that yung option contract in itself is a contract. So, dahil contract siya, meaning, kailangan ding ng perfection. So, kailangan rin magkaroon ng meeting of minds for that option. So, if in our example, nung sinabi ni Pogi na, I will give you 10-day period to decide, okay? Para to make up your mind kung bibilhin mo ba itong lupa or bahay ko. If you would give me 1,000 pesos or 10,000 pesos, depende kung ano yung offer ni Pogi at inaccept ni Ganda, so magkakaroon ngayon ng option contract. And so, nung binayaran ni Ganda si Pogi ng option money, dahil may option contract, hindi pwedeng mag-withdraw si Pogi. Okay ba? Malinaw? Okay. Pabalik-balik? Hindi. Kasi iba yung point na to sa option contract to. Okay. So, that's it. That's Article 1324. Let's proceed with Article 1325. Si Article 1325 naman speaks about the business advertisement. Ang sabi, unless daw it appears otherwise, yung mga business advertisement of things for sale are not definite offers. Okay, hindi daw yun mga offers, but ang sabi, they are mere invitations to make an offer. So, if we will be asked kung yung business advertisements ba ay definite offers, ang sagot ay it depends. 1, if it appears to be a definite offer containing all the specific particulars needed in a contract, then it is really a definite offer, di ba? Kasi sabi, unless it appears otherwise. Pero kung hindi naman, it does not appear to be a definite offer, then ang sabi, it is just a mere invitation to make an offer. So, papaano mo malalaman if it is in a definite offer? Sabi, pag all the specific particulars needed in a contract ay nandoon na. Now, pag hindi naman, masyadong broad lang, then that is a mere invitation to make an offer. Okay. Tayo na lang magbasa. But anyway, if ganyan daw pagkakasabi, that is an example of a definite offer. Makikita mo na lahat ng specific particulars na kailangan para sa kontrata ay nandyan. So, if yung buyer or yung offeree nag-decide na tanggapin yan, then meron ng kontrata. Okay? Pero if yung example is ganito pagkakasabi, yan. Then, makikita mo na yung may mga importanteng detalye na hindi pa nakalagay. So, meaning the advertisement is not a definite offer. Okay? So, it is just a mere invitation pa. It's as simple as that. Basta take note nyo na lang yung mga examples. Anyway, let's proceed with Article 1326. Ito naman, advertisement din, pero this is more on advertisement for bidders. Okay? Si Article 1326 tell us that yung mga advertisement for bidders daw generally they are not definite offers. So, when you say dahil hindi nga sila definite offers, then meaning they are just but simply an invitation to make proposals, right? Kumbaga, in reality, yung talagang gumagawa ng offer ay yung mga bidders. Yung nag-a-advertise, they are just inviting bidders to make proposals. Okay? So, the advertiser is free to accept or to reject kasi hindi naman siya definite offer nga. And para magkaroon ng contract, kailangan i-accept ni advertiser yung proposal or yung offer nung either saan doon sa bidders, okay? Basta, eto lang. Most advertisements are simply invitations to make an offer and are not offer in themselves, okay? Since not all the necessary terms can fit in that advertisement, right? So, general rule, yung mga advertisement talaga are mere invitations unless the contrary appears na makikita mo na definite offers talaga. But general rule, advertisements are just invitations, okay? So, let's proceed to another topic. Let's proceed with Article 1327. This more on talks about the capacity of a person to enter into a contract or to give a consent. Sabi ni Article 1327, the following cannot give consent to a contract. Number 1, sabi niya, unemancipated minors. And second, yung mga insane or demented persons and the deaf mute who do not know how to write. Okay, so merong tatlo. Una is yung unemancipated minors. Second are yung mga insane or demented persons. Unless they acted during lucid interval. Kasi yung mga baliw daw, hindi naman yan all the time baliw. Merong times na nasa tamang pag-iisip sila. So, if yung contract, they enter that contract during their lucid interval, so they have the capacity actually to give consent at that time. So, malamang valid yung contract nila. Okay? And yung third is yung sa mga deaf mutes who do not know how to write and read. Kasi yung rationale dito, they are not capable of understanding things. Unless nga kung marunong silang magsulat at magbasa, then at least masasabi natin they are capable of understanding. So then in that case, they have the capacity to give consent, right? The reasons for disqualifying them or for making them incapable of giving consent dahil dun sa situation na rin nila, like si minor, they are presumed na they are not yet or they are still unable to take care of themselves fully, right? Parang wala pa silang capacity to make that intelligible decisions. Kumbaga, these minors, yung mga insane, and the deaf mutes who does not know how to write are very prone to being, maging biktima ng fraud, di ba? So, yun yung rationale dito. And to tell you, etong mga contracts who are entered into by person who are incapacitated, person to give consent, are voidable. Yung mga kontratang na-enter nila ay voidable, meaning valid until annulled. Meron kasing dalawang uri ng voidable contracts. First is yung contracts where one parties are incapacitated to give consent. So that is under Article 1327. And then later on, we will also be discussing yung sa Second naman na kinds na or class ng voidable contracts, yun naman pag yung consent ng one party are vitiated, such as when you say vitiated, meaning merong error, fraud, violence, intimidation, or undue influence na nangyari kung kaya nagbigay siya ng consent. So, yun. Two classes of voidable contracts. First, pag yung one party is incapacitated to give consent, and second, pag yung consent is vitiated. Now, I think that's it. That's Article 1327. And so, let's proceed with Article 1328. Now, Article 1328 also talks about nagdagdag din siya ng ibang situation kung saan voidable contracts rin by reason of incapacity pa rin, okay? Incapacity of a person to give consent. Sinabi niya rin, actually na-mention ko kanina, pero nandito pala siya kay Article 1328, yung mga insane, they are capable of giving consent naman during lucid interval. Okay, so kahit pa na-declared na siya as a baliw, insane, may court order that that person is, yun nga, judicially declared insane na, pero nag-enter siya into contracts, pwede pa rin siyang maging valid, but we just have to prove that that contract was entered into during his lucid interval. Okay? Now, dito rin sa second sentence ng Article 1328, sabi, contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. So, yun nasabi ko, nagdagdag lang siya ng situation kung saan, voidable contracts by reasons of incapacity to give consent. So, eto nga, pag daw yung contract was entered into in a state of drunkenness, tapos, during a hypnotic spell, kasi daw, ang rationale naman dito, during that state daw, during drunkenness or hypnotic spell, nagkakaroon ng temporary, complete loss of understanding. And so, ini-equivalent nila to sa temporary insanity rin. Okay? So, I think that's it. That's about Article 1328. Let's now proceed with Article 1329. So, Article 1329 naman talks about modification sa incapacity. Sinasabi niya dito na yung incapacity as declared in Article 1327, sabi, pwede naman siyang modify or subject to modifications determined by law. Yun nga. Kasi may mga instances rin naman na although etong mga taong to are incapacitated, they can still enter into a contract or a valid contract. Example, sinabi rin naman ng batas that a contract is valid if entered into through a guardian or a legal representative. Pwede naman. Tapos, pwede rin if yung si minor, although incapacitated to give consent nga sana siya. However, si minor actually can enter into a contract for life, health, and accident insurance, diba? Although merong mga special qualifications. So, that's it. Yun yung ibig sabihin ni Article 1329. Let's proceed with Article 1330. So, Article 1330 provides that a contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. So, actually, ito yung sinasabi ko kanina, na-mention ko na siya na two classes of voidable contracts. First is pag yung person or one of the parties is incapacitated to give consent. So, na-discuss na natin siya. Now, eto naman is yung sa second class, doon sa mayroong mga vitiated consent. Kumbaga, another term for this is, or other refers this as a vices of consent. Kasi, in order that a consent may be valid for purposes of a contract, kailangan hindi lang siya basta nag-exist, kumbaga. So, ano ba ang dapat para sa consent? Kumbaga, requisites or characteristics of a consent na dapat. First, it is intelligent. Meaning, yun nga, dapat yung nagbibigay ng consent has the capacity to act, has the capacity to give that consent. Tapos, second, dapat yung consent is free and voluntary. Baka naman napilit lang, hindi talaga gusto, through fraud, violence or intimidation pa lang ginawa, di ba? So, kailangan din it is free and voluntary. And then third, sabi, it is conscious or spontaneous, meaning walang vitiation ng consent. Kumbaga, yung consent ay binigay hindi by mistake, hindi by fraud, hindi by undue influence, walang ganon, okay? Dapat it is intelligent, meaning yung nagbigay must have the capacity to give that consent. Second, it is free and voluntary, freely given, hindi pinilit, walang violence, walang intimidation, okay? And third, it is conscious or spontaneous, meaning there is no mistake, there is no fraud. And so, Article 1330 enumerates causes for a vitiated consent. First nga dito is mistake, tapos violence, intimidation, undue influence, tsaka fraud. So, pag present ang alinman dito sa kanila, dun sa consent, meaning that contract is voidable. And to repeat, para mas tumatak sa isipan, voidable contract is binding and valid naman. Unless annulled. Paano ba siya ma-annulled? Through proper action in court din naman. So, valid until annulled. Yun yung status ni voidable contracts, in which we will have a separate video regarding this sa voidable dun sa mga defective contracts. Okay? So, I guess wala na rin atang dapat i-discuss. So, let's proceed with Article 1331. Now, medyo mahaba tong provision na to, pero simple lang at madali lang ang ibig niyang sabihin. It just answered the question ganito. When does mistake or an error vitiates consent? Okay? Kailan mo ba masasabi na yung mistake or yung error na yon is sufficient to vitiate consent? Now, Article 1331 says that ito yung mga requisites for mistake to vitiate consent, ha? First, ito, the error or yung mistake mismo, it must be substantial, okay? Substantial regarding saan? First, object of the contract. Second, the conditions which principally moved or induced one of the parties. Diba? And third, identity or qualifications of one of the parties. Okay? So, dapat may substantial error or mistake as to that aspect, either the object of the contract, yung conditions which principally moved or induced one of the parties, and third, identity or qualifications ng one of the parties. And yung last paragraph, meron dyan, a simple mistake of account shall give rise to its correction. So, meaning, pag simple error or mistake as to account lang, hindi naman kailangan ng annulment of contract. Pwede namang correction lang. Okay? Now, let's discuss on these requisites, yung sinabi ko kanina. One by one. Una, etong sa the error must be substantial. So, kailan mo ba masasabi na yung error is substantial? Hindi lang siya minimal, kundi substantial. Now, you just have to determine ito. If kung yung isang party would still enter into that contract kahit pa alam niya na merong mali or alam niya na mali or may mistake dito, okay? Pag kahit na alam niya yung mistake, yet mag-enter pa rin siya sa contract na yan, then meaning, hindi yan substantial error. Kasi if substantial error yan, meaning, kung had it been na alam niya yung mistake or error na yan, hindi sana siya magbibigay ng kanyang consent. Okay? Yun yung concept ng substantial error. Now, to better understand this concept ng substantial error as to the object of the contract or the conditions which have principally moved one or both parties into the contract, or yung sa mistake as to the identity or qualifications of one of the parties, I think much better if i-discuss natin siya through an example. So, first, let's take an example kung paano mo masasabi na nagkaroon ng mistake regarding the object of the contracts. Okay? Eto. Halimbawa, if si Pogi at si Ganda, they enter into a contract. Ang contract nila is for Pogi to deliver 32 karat gold necklace to Ganda. Now, if later on, upon delivery, ang dumating is hindi 32 karat gold, but only 16 karat gold. Lamang, kung alam lang ni Ganda na 16 karat gold lang yung object na ibibigay ni Pogi sa kanya, malamang hindi naman siya papasok into that contract. Right? So, another example, dito naman tayo sa mistake regarding the condition of the contract. Halimbawa, eto. If si Pogi delivered to Ganda a car, thinking that Ganda will pay when she will have money. So, pautang pala. Eto namang si Ganda, umayag siya. Tinanggap niya yung delivery, agrees to that in the belief that it is donated to him by Pogi. So, meron talagang mistake as to the condition of the contract. Right? So, another example, dito tayo sa mistake regarding the identity or qualifications of one party. Ito. If si Pogi nag-donate siya kay Ganda ng kanyang sasakyan, thinking that Ganda is a lawyer who is really a doctor. Dito, makikita mo na hindi naman substantial yung mistake. Okay? The mistake here is not that material or substantial as to avoid the contract. Pero if yung mistake as to identity pala is ganito, if Pogi donated to Ganda a car, thinking that Ganda was his half-sister, but later on it turned out that Ganda is not related to Pogi, hindi pala si Ganda ang kanyang half-sister, and so the mistake as to the identity of Ganda is material. Because actually, obviously, her identity was the principal reason or consideration kung bakit binigay ni Pogi ang kanyang sasakyan. Okay? Now, let's take an example also para dito sa last sentence, itong mga simple mistake that will give rise only to correction. Halimbawa, ganito. Si Pogi, pumunta siya kay Ganda, bumili siya ng 10 pieces ng ballpen. And each ballpen cost, say, 6 pesos and 50 centavos. Tapos, instead of a total amount na dapat niyang bayaran is 65, diba dapat? Kasi 650 times 10, 65. Pero instead of paying or having in that contract na 65 pesos, ang nangyari, ang nasulat doon ay 75 pesos and it was made by mistake. So, and actually, the mistake is merely an error in computation, an error in account. And so, yung example na there will only be correction. Hindi naman kailangan ng annulment of contract, right? Kasi hindi naman substantial yung error or mistake. Now, before we proceed to with Article 1332, gusto ko lang i-mention na yung mga error or mistake which could have been avoided rin naman ng parties, or kumbaga, kung nag-exercise lang siya ng ordinary diligence ay maiiwasan sana ang mistake, or if yung mistake is actually so obvious that nobody could have made it, it will not invalidate consent rin. Okay? So that's it. Let's proceed with Article 1332. This provision naman talks about the rule in case of inability to read or understand ng isang party. Actually, ganito siya. As a general rule, the presumption is, the natural presumption is that one always acts with due care and so signs with full knowledge of all the contents of a document. This presumption is not applicable in Article 1332. If ever yung isang party who is unable to read or understand, if ever nag-allege siya ng mistake or fraud, the other person or the other party who is enforcing the contract has the burden of proof to show that he actually has fully explained that contract dun sa other party who is unable or unable to read or to understand. Now, these situations or these provisions contemplates two situations actually, diba? Or two cases. First, when one of the parties is unable to read. So, meaning kasama dito yung mga bulag, diba? And second, if the contract is in a language not understood by one of the parties. Okay? Now, example, if si Pogi is actually, sabihin na natin na bulag siya. And so, pumirma siya ng isang kontrata through a thumb mark kasi nga bulag. So, by thumb mark lang. Believing that that contract is actually a contract of mortgage. Okay? Mortgage lang. Pero sa totoo pala, deed of sale pala siya in favor sa kanyang supposedly a relative na in the person of Ganda. And so, if Pogi claims afterwards nag-claim siya nag-allege siya ng fraud or mistake, then Ganda has the burden of proving that she did not take advantage of her situation or position, and that failure to do so, kung hindi niya ma-prove that she did not take advantage of the situation as a relative of Pogi who is blind. And so, yung deed of sale can actually be annulled. Okay, so let's proceed to the next provision, Article 1333. Medyo mahaba pa rin kahit na malayo na yung nadidiscuss natin. Okay, so Article 1333 provides that there is no mistake if the party alleging it knew the doubt, contingency, or risk affecting the object of the contract. Okay? So, madali lang naman siyang intindihin. If may knowledge of doubt or risk naman itong other party, then there is no vitiation of consent. Walang vitiated consent. Okay? It will just be assumed that the party was willing to take that risk. Ganon lang. And so, he cannot claim mistake afterwards. So, example, if may binibenta sa yung lupa and then you are actually informed na meron pang pending litigation kasi maraming claimant as to who is really the owner of that land. And so, if later on, binili mo ang lupa, and then later on, yung seller mo is natalo as to his claim over that land, then you cannot claim mistake rin. Okay? You cannot annul that contract dahil claiming mistake, kumbaga merong vitiated consent. Wala. Kasi in the first place, alam mo, and so you have assumed or you have taken or you are willing to take the risk or the chance. Okay? So, it's as simple as that. Let's proceed with Article 1334. Article 1334 provides that mutual error as to the legal effects of an agreement with the real purpose of the parties is frustrated may vitiate consent. So, yes, this article provides for requisites kung kailan ba yung mutual error ay magiging makaka-vitiate ng consent. So, first and foremost, dapat may mutual error. Second, dapat yung error, it must refer to the legal effect of the agreement, di ba? And then third, yung real purpose of the parties is frustrated. Yun yung sabi ni Article 1334 pag binasa mo rin naman. So, for example, if si Pogi and si Ganda nag-enter sila into an agreement, a contract, gusto nila mag-enter into a contract of mortgage. Pero silang dalawa, they executed a written document and that document is one for sale. Okay? So both parties thought that the deed of sale has the same effect with that of mortgage. Okay? So nagkaroon nga ng mutual error and that mutual error refers to the legal effects. Akala nila same legal effect yung deed of sale tsaka yung deed of mortgage. Tapos yung third, the real purpose of the parties is frustrated, malamang. Kasi yung na-execute is deed of sale when in fact yung nasa isip nilang dalawa is mortgage. So in this scenario, nagkaroon ng vitiated consent. And so, yung contract nila can be subject for annulment. Okay? Yung remedy dito is annulment. Now, we will distinguish this later with reformation. Sa discussion na siguro when we reach our discussion with reformation. Kasi medyo may similar sila, kaya kailangan natin i-distinguish kailan ba annulment and kailan reformation. But yun na nga, when we reach the topic on reformation na. For now, let's move on to the next topic, Article 1335. So, we're now done with the mistakes, diba? Yung diniscuss natin kanina, kung nahalata nyo, yun ay in-depth ng mistakes as a ground for vitiated consent, okay? Now, another ground, diba, or reasons for vitiated consent is violence or intimidation. So, this provision, Article 1335, actually talks or speaks about violence and intimidation. So, ano ba yung pinagkaiba ng dalawa? Violence is more on physical coercion. Tapos, intimidation, more on moral or mental coercion. So, pag violence, more on physical, tapos intimidation is more on internal coercion, di ba? Anyway, pareho lang naman yung dalawa, violence and intimidation results to vitiated consent pag yung consent ng isang party was obtained through violence and intimidation. So, example, when you say violence, like if yung isang party pala is repeatedly hit every time he refuses to sign the contract. So, yung consent niya, although pumirma siya sa kontrata, alam natin na yung consent niya is hindi genuine, kundi isa siyang napilit lang dahil sa violence na in-employ nung kabilang party. Now, when you say intimidation, ang magandang halimbawa rin dito is if yung isang party nga din is napilit lang pumirma ng kontrata dahil merong naka-point, nakatutok na baril sa kanya. And so, if hindi siya pipirma, pwede siyang barilin, right? So, yung consent niya is also hindi genuine. So, meaning meron nga vitiated consent and that makes that contract voidable. Now, let's discuss kung ano ba ang requisites for violence to vitiate consent. Lahat ba ng violence, di ba? Lahat ba ng klase ng violence, kahit minor or hindi naman serious, is pwede na ba maka-vitiate ng consent? So, eto. There are actually two requisites for violence to vitiate consent. And that is found in Article 1335 lang naman. First, employment of a serious or irresistible. So, meaning talagang serious and irresistible. When you say irresistible, meaning hindi talaga ma-resist. Baka mas malakas talaga siya. Kasi naman, kung nung ikaw ay mas malakas, naku, pwede mo naman palang suntukin, di ba? And yung second requisites for violence to vitiate consent is dapat yung serious or irresistible force, yun talaga yung reason why the contract was entered into, okay? Yun yung reason kung bakit ka pumirma. Dahil dun, ang sakit-sakit na ng katawan mo, binubugbog ka na, every time you refuses, bugbog ulit. So, hanggang sa napilit ka na, pumirma na lang. Okay? So, that is violence, and because of that violence, it vitiates consent, and so the contract is voidable. Now, ano naman ang requisites for intimidation? Kung si violence is actually in the first paragraph ni Article 1335, si intimidation ay nandito sa second, third, and fourth. So, eto. I-discuss na rin naman natin siya. Mahalaga tong provision na to, kaya i-discuss natin ng mabuti. Anyway, eto. So, requisites for intimidation to vitiate consent. Number 1, dapat daw reasonable and well-grounded fear. Okay? So, kailan mo ba masasabi na yung fear is reasonable and well-grounded? Okay? It depends actually upon the circumstances, including, syempre, consider din natin yung age, condition, and the sex of the person concerned. Yan ay actually nasa kay third paragraph ng Article 1335. Yun is i-consider mo talaga. Now, another requisites is, sabi, di ba, una, reasonable and well-grounded fear. Ang kasunod, of an imminent and grave evil. Sabi pa, upon his person, property, or upon the person or property of his spouse, descendants, or ascendants. So, hindi siya exclusive sa sarili mo or sa property mo lang. Kasama din doon is yung sa yun nga, yung ascendants, meaning parents, grandparents, descendants, mga anak, or yung asawa mo. So, threat could also be directed to them, hindi lang sa'yo. So, if threat is directed to those, yun nga, yung family mo, and then yun yung reason kung bakit ka na nag-enter into contract, then that is also a vitiated consent, and so the contract is voidable. Dapat nga, yun na, sinabi ko kanina, it must have been the reason why the contract was entered into. Okay? Kasi kung kahit na wala pala yung intimidation na yon, talagang you are going to enter into that contract din naman, so then it's not a vitiated consent, right? Now, another requisites is dapat daw yung threat must be of an unjust act, an actionable wrong. Sabi ganon, di ba? Well, ang ibig sabihin nito is that kung yung threat pala is to enforce one's claim through a competent authority, then that claim is just or legal, meaning walang vitiated consent kasi yung claim na pinapantakot niya sa'yo is after all just or legal. Diba? Basahin nyo yung last paragraph ng Article 1335. A threat to enforce one claim through competent authority if the claim is just or legal does not vitiate consent. So, kung yung threat naman pala is just or legal, then walang vitiated consent, meaning valid yung contract na yon. Okay? So, ano ba? Example, kung yung may utang ay napilitang magbayad dahil tinakot siya ni creditor na kung hindi siya magbabayad, siya daw ay sasampahan ng kaso, ay malamang the claim of the creditor is just and legal. So, hindi yung pagbabayad niya is not a vitiated consent kasi after all, just and legal nga yung claim ni creditor, di ba? So, that's Article 1335 na ata. Yes, we can proceed with Article 1336, which also discusses on, or speaks about violence or intimidation. Dito naman, sinasabi niya lang actually is that kahit pa yung nag-exercise or nag-employ ng violence or intimidation was a third person, hindi naman yung kakontrata mo, and yet, yun yung reason kung bakit ka nag-enter into that contract, sabi that contract can also be annulled, meaning voidable pa rin yun. Kasi, kumbaga, still, yung consent mo was vitiated, okay? Yun, that's it. It's as simple as that. Kahit third person yung nag-employ ng violence and intimidation, pareho lang. Provided siguro na lahat ng requisites na sinabi natin or diniscuss natin kanina is nandun, present pa rin. Okay? So, anyway, ano pang inaantay natin? Let's proceed to another grounds for vitiated consent. Dito naman is undue influence. So, that's under Article 1337. Sabi, there is undue influence daw when a person takes improper advantage of his power over the will of another, depriving the latter of a reasonable freedom of choice. So, requisites ulit ni undue influence, dapat may improper advantage. Tapos, yung power over the will of another, di ba? Improper advantage of his power over the will of another. And because of that, nagkaroon ng deprivation sa reasonable freedom of choice. And yes, si Article 1337 mismo is nag-provide siya ng mga circumstances na i-consider in determining undue influence. Sabi, confidential, family, spiritual, and other relations between the parties. Okay? So, yung relationship mismo ng between the parties. Another circumstance is yung mental weakness ng isang party or ignorance or financial distress. So, that conditions or circumstances will also be considered sa pagdetermine ng undue influence. Pero take note, to vitiate consent, dapat yung influence must be undue, diba? Sabi nga, undue influence. So, meaning if yung influence is due or meaning allowable lang din naman, like when nagkaroon lang ng argument or persuasion, so that is not prohibited by law. Okay lang yon, hindi siya makakapag-vitiate ng consent. What vitiates consent is undue influence. And in determining undue influence, yun nga, you have to consider yun yung sinabi natin kanina. Okay? So, let's move on to another grounds to vitiate consent. Now, actually, mas maganda to, topic na to, kasi sa undue influence. So, proceed na tayo dito. So, fraud. We are now discussing fraud as a ground to vitiate consent. So, sabi nga, there is, according to Article 1338, there is fraud when through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. Alam nyo, naiintindihan nyo naman ata yung fraud. In ordinary parlance, di ba? Pero yun na rin naman yung ibig sabihin. Although in legal aspect, meron dalawang fraud. Alam ko na, na-discuss na natin to before when we discuss yung sa obligations pa na topic. Anyway, meron dalawang fraud. Dolo causante or yung causal fraud, and meron din tayong dolo incidente or incidental fraud. When you say dolo causante, meaning it is for, ito yung fraud na kung saan vitiated consent talaga, na kung walang fraud na yan, yung isang party ay hindi sana i-enter. So, this is Article 1338. Now, pag sinabi mong dolo incidente, eto naman is incidental fraud. Dito, kahit na meron or wala yung fraud, the parties would have agreed just the same. So, kaya nga, incidental lang siya sa causing ng or sa pagbigay ng consent. Most likely, it will not invalidate that contract. Hindi naman siya magiging magkakaroon ng vitiated consent. Wala naman, pero it would be a ground for or to claim for damages. So, yan yung kinds of fraud as to during the celebration, during dun pa sa perfection at the time of the perfection of the contract pa. Pero pag dun na sa fraud in the performance of the obligation, yun yung na-discuss natin before. So, that kind of fraud presupposes the existence of an already perfected contract. Meron na, dun na sa pag-perform, dun na yung pandarayan nangyari, and so, yun din, that kind of fraud is also not a ground to annul that obligation or contract, but then, claim ka na lang din ng damages. Okay? If naalala nyo yung example natin dito is yung obligation to deliver a specific rice, tapos ang ginawa, yun naman talaga yung dineliver, pero you mixed it with another lower, mas mababang quality ng rice just to manlaya, right? So, what are the requisites for dolo causante? Kumbaga, first, the fraud must be material and serious. That is, yun nga, it really induced the consent. Yun talaga yung reason which na-induce yung isang party to enter into that contract. Now, second requisites, the fraud must have been employed by only one of the contracting parties. Kasi pag yung dalawa committed fraud, then the contract would remain valid. After all, pareho silang dalawa. Third requisites, there must be a deliberate intent to deceive or to induce. So, therefore, yung misrepresentation in good faith is not fraud. Kumbaga, akala mo lang din talaga, hindi mo sinasadya, hindi mo talaga intention na mandaya. Nagkamali ka lang, kasi in good faith, akala mo rin talaga is, kumbaga, ikaw misma ay naniniwala dun sa pinaglalaban mo. So, wala namang fraud doon. Now, fourth requisites, the other party must have relied on that untrue statement and must himself not be guilty of negligence in ascertaining that truth. Okay? So, yun, dapat dun, yung isang party is nag-rely nga din siya dun sa untrue statement mo. And so, wala ding negligence. Kasi kung may negligence, so, hindi na rin siya magiging vitiated consent. Right? So, ano ba yung mga example ng contract, which is, yan, meron ngang material and serious fraud, and so, vitiated consent. Example, if sa insurance contract, tinago mo, there is a concealment of an illness para ma-approve ka for insurance. And then, if naaalala nyo pa yung previous example ko dito, Bigla ko lang naalala. Alam niyo yung nagbenta siya ng jewelry tapos sabi niya it is made out of diamond and believing na diamond nga yung sing-sing na yon na may diamond yon, bumili si isang party, binili mo. So there is fraud. Kasi nag-rely ka sa sinabi ng seller na yung stone on that ring is made out of diamond when in fact it is just made of an ordinary glass. So that is actually vitiated consent, and so yun na nga, voidable contracts pa rin kasi vitiated consent. Okay, feeling ko okay na si Article 1338. So let's proceed with Article 1339. Okay, so let's discuss, fraud pa rin naman to, pero this is fraud by concealment. Kumbaga, sinasabi lang ni Article 13 and 39 that failure to disclose facts, so meaning nga concealment, when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. So, yun nga. It is actually a fraud by concealment. Sabi, failure to disclose facts nga raw constitutes frauds. Pero dapat, when there is a duty to reveal them. Okay? Hindi mo sinabi when in fact you have a duty to disclose that facts and yet hindi mo sinabi, nilihim mo. And so that constitutes fraud. Okay? So, Article 1339 also provides for an example kung kailan mo masasabi na there is a duty to reveal. Sabi daw, when the parties are bound by confidential relations. So, the best example for this is in case of partnership, di ba? Kasi yung partners in partnership are bound by confidential relations. So, example, if X and Y are partners engaged in the real estate business. Tapos, yung isang partner, suppose si X, he learned, okay, nalaman niya na may third party who was interested in buying a parcel of land na pag-aari nga ng partnership, even for a high price, okay? Now, ang ginawa ni X is kinonvince niya si Y na ibenta sa kanya ang lupa. And then, so, nung nabenta na sa kanya, naging sa kanya na, hindi na sa partnership, then sa kanya, binenta ulit doon kay C at a big profit. Okay, nagets nyo? So, in this case, CX is actually guilty of fraudulent concealment. Why? Because actually, as a partner to Y, he has the duty to disclose facts na merong connection or relevance doon sa interest ni Y in their partnership. Hindi alam ni Y, mayroon pa nang gustong bumili ng lupa ng partnership. And so, at the expense of Y, etong si X ay marunong. So, pinilit niya yung partner niya na ibenta sa kanya yung lupa, tsaka niya binenta kay C. And, of course, at a big profit. Sabi ni Article 1339, that is fraud by concealment. And so, if merong fraud by concealment, meaning that contract is actually voidable, di ba? Vitiated consent. So, that is Article 1339. Let's proceed to Article 1340. Dito naman, si Article 1340, it talks about the usual exaggerations in trade. Sinasabi lang naman na yung usual exaggerations in trade, when the other party had the opportunity to know the facts, yun daw ay hindi fraudulent in themselves. Okay? Actually, this article stresses the rule of caveat emptor, meaning let the buyer beware. Okay? Yung maxim na caveat emptor simply means that a buyer must be on his guard. Kasi it is natural tendency naman talaga for merchants and traders to resort to exaggeration in their attempt to make a sale at the highest price possible, di ba? So, in effect, the law does not consider such exaggerations fraudulent. Okay? So, example, halimbawa, sa mga nagbebenta ng mga pampapayat, pampaputi, ano pa ba, yung mga skincare products, alangan naman sabihin nila, okay to, pero mas maganda yung iba. So, syempre, palaging the best and first class quality yung binibenta nila. Right? So, that is just a normal exaggerations in trade. Hindi siya fraudulent. Yun lang yung ibig sabihin ni Article 1340. Let's proceed with Article 1341. Ito naman is about sa expression ng opinion. So, Article 1341 says that a mere opinion does not signify fraud unless thou made by an expert and the other party has relied on the former's special knowledge. So, as a general rule, pag yung mga expression mo lang naman, expression lang ng opinion mo, that is your opinion, hindi naman talaga siya fraudulent, okay? So, under this provision, ano ba ang mga kailangan or ano yung hahanapin mo in order for that opinion to be, sabihin natin, maging fraudulent. First, if it is made by an expert. Second, if yung other party has relied on that expert's opinion. And third, the opinion turned out to be false or erroneous. So, unless hindi naman siya expert opinion, yung mga opinion mo lang, halimbawa, is yung iyong lupa, and in your opinion, your land is actually a first class. But then later on, it turns out to be second class lang pala. So, the sale is not fraudulent. Particularly if yung buyer naman has the opportunity to examine yung land for himself. Pero kung pumunta ka sa isang seller and that seller is selling a product kung saan expert talaga siya, and dahil yung reason kung bakit ka bumili ng product niya is that nag-rely ka sa expert opinion, okay, ng seller mismo. So, in that case, the contract is voidable because yan ay naging fraudulent. So, vitiated consent ulit. So, yan. Unless naman hindi siya expert opinion, and kahit pa expert opinion, pero meron kang time to ascertain kung totoo ba yung mga sinasabi niya and that hindi naman talaga yung opinion niya ang naging reason kung bakit mo binili yung product. Wala, hindi siya voidable contracts, walang vitiated consent, hindi siya fraudulent. So, that's it. That's Article 1341. Let's proceed with Article 1342. Ito naman is dun sa misrepresentation by a third person. Sabi, yung misrepresentation by a third person daw does not vitiate consent. So, eto, yun yung general rule. Misrepresentation by third person does not vitiate consent. Pero meron na naman siyang exception unless such misrepresentation has created substantial mistake and the same is mutual. Now, ganito. Di ba si third person, alam na natin, yun yung mga hindi parties or privy sa contract. Okay? Stranger siya sa contract ninyo. Eto. Na-discuss natin kanina na if yung third person should commit violence or intimidation on one of the contracting parties, at yun yung reason kung bakit nagkaroon ng vitiated consent, then that contract is voidable. Pwedeng ma-cancel, pwedeng mapa-annul. However, pag binasa mo si 1342, iba, di ba? Pag yung third party daw nag-commit ng fraud, ang makukuha niya lang actually is damages. Hindi daw siya, it does not vitiate consent daw. So, meaning, hindi pwedeng mapa-annul or makancel yung kontrata. So, the remedy of the injured party might just be damages or actually damages lang talaga. So, yun yung pinagkaiba. Although, nag-provide din naman ng situation wherein yung fraud that is committed by a third person vitiate consent if it has created mutual and substantial mistake, di ba? Dalawa yun. Take note, dalawa. Substantial mistake and mistake is mutual or mutual substantial mistake. So, yun. Pag ganon, it vitiates consent and so, pwede nang mapa-annul yung contract na in-enter nyo. Okay, example. Suppose, palitan na natin ganda and pogi na tayo parang mas madali at naiintindihin. So, if ever, si Ganda, bumili siya ng lupa kay Pogi for, say, 1,000 pesos per square meter. Tapos, yung reasonable price of the land in the same vicinity actually is 2,000 pesos per square meter. Pero, binenta lang siya ni Pogi kay Ganda at an amount of 1,000 per square meter kasi naniwala siya sa sinabi ni Beauty kung saan nagsabi na 1,000 per square meter lang talaga yung value or yung market value ng lupa dun sa kanila. And so, in that case, yung contract cannot be annulled. Why? Because yung fraud, although merong fraud, it was committed by Beauty and Beauty is a third person. Doon naman sa example, hindi naman siya pasok sa exception kung saan it creates substantial mistake which is mutual sa both parties. Okay? Kasi nga, sabi ni Article 1342, misrepresentation by a third person does not vitiate consent. Pwede lang if ma-prove ni Pogi that or if yung nangyari pala is that nagkaroon ng connivan si Ganda at si Beauty. Kumbaga, nagkaroon ng sabwatan para mas ma-lower yung price ng pagbebenta ni Pogi. So, in that case, dahil may participation na rin si Ganda sa fraud, then that's the time na pwedeng ma-annul ni Pogi ang kanilang kontrata on the grounds of fraud committed by Ganda. Okay? Now, another example. Suppose naman, etong si Pogi is an owner of, yun nga, parcel of land sa kaniyang probinsya. Tapos, etong si Ganda, gusto niyang bumili ng lupa sa province ni Pogi for, kasi gusto niya daw mag-build ng factory. Eto si Beauty, a third person, sinabi niya kay Pogi and Ganda na yung place kung saan nandoon yung lupa ni Pogi is actually an industrial zone. On the strength of that misrepresentation made by Beauty, yung lupa ay binili ni Ganda para sa kanyang factory, okay? And it turns out later on that that area pala is a residential zone. So, hindi pwedeng mag-construct si Ganda ng factory. And so, the contract of sale may be annulled because meron siyang substantial mistake which is mutual. And sabi ni Article 1342 nga, unless such misrepresentation has created substantial mistake and the same is mutual. Yun yung ibig sabihin ni Article 1342 in example, di ba? So, that's it. That's Article 1342. Let's proceed with Article 1343. Well, madali lang din to. Hindi siya, kaya madali lang din natin i-discuss. Ito naman, discusses on the effect of misrepresentation that is made in good faith. Sabi nga, misrepresentation made in good faith is not fraudulent, but may constitute error. So, either way, vitiated consent. Kasi, di ba, mistake and error, vitiated consent. Pag may fraud, vitiated consent. Pero, definitely, etong fraud is more serious than mistake. Hence, yung party which is guilty of fraud is subject to a greater liability. Kaya sinabi lang ni Article 1343, misrepresentation made in good faith is not fraudulent, but may constitute error. So, example, dun na rin sa example natin before, yung binenta ni Pogi or bumili siya si Ganda bumili ng sing-sing which she expects to be a diamond ring pero it turns out to be just made out of a glass or just an ordinary glass. So, if in that scenario, eto talagang si Pogi ay hindi niya rin naman alam na hindi pala made of diamond ring yung binibenta niya. Kumbaga, in good faith, akala niya rin talaga diamond ring yung sing-sing na yon. So, in that case, yung misrepresentation is not fraudulent, pero may mistake pa rin. And so, voidable contract on the ground of mistake or error and not on the ground of fraud. Yun lang. It's as simple as that. So, let's proceed with Article 1344. Well, Article 1344, madali na rin siya kasi yung concept ay medyo na-discuss na natin earlier, pabalik-balik na. So, this talks about yung dalawang klase or kinds ng fraud, the dolo causante at saka yung sa dolo incidente. Tapos sabi nga natin, pag dolo causante, yun yung mayroong vitiated consent kasi yung fraud is actually the cause kung bakit nag-enter into a contract yung isang party. And so, it is a ground for annulment. Now, pag sinabi mong incidental, hindi siya ground for annulment, pero magiging liable yung guilty party to pay damages. Yun yung nasa second paragraph naman. Now, paano mo masasabi that a fraud is a causal fraud? Sabi, first, it should be serious. And second, it should not have been employed by both contracting parties. Baka nga naman kasi pareho sila. Kumbaga, they are in pali dilecto. Hindi rin pwede. So, that is not causal fraud. Kasi pag yung both parties naman ay nag-employ ng fraud, pareho silang mandaraya, oh my God, right? So, meaning, yung fraud neutralizes that of the fraud of the other. And so, i-consider siya ng batas as valid. Total, equal footing naman sila. Parehong nag-employ ng fraud. And so, actually, that rule is based on the principle that he who comes to court must come with clean hands. Alam niyo yun, hindi ibig sabihin nun na bago ka pumunta ng korte ay maghugas ka ng kamay. Iba yon. Ito, yung principle na to, dapat kung you will seek a judicial relief, dapat wala kang ginawa o hindi ka rin guilty. Okay? Hindi ikaw yung guilty party o wala kang ginawang masama. Okay? Wow, malapit na nating matapos ang discussion with consent. Tapos meron pang object of the contract and yung cause and consideration. Wala na akong boses. Ano nang nangyayari? My God. Anyway, sige. Article 1345 and Article 1346 talks about simulation of contracts. So, when you say simulation of contracts, ito yung mga mutual agreement by parties, pero hindi siya nag-e-express ng totoong intention ng parties, okay? These are mutual agreements of parties which does not express the true intent of the parties. Now, it could be absolute or relative. Sabi nga ni Article 1345, absolute daw siya if it takes place daw when the parties do not intend to be bound at all. So, wala talaga silang intention to enter into a contract. And sabi din, it is also, or I mean, the simulation of contract is relative if when the parties conceal their true agreement. So, eto, meron silang intention to enter into a contract, pero naka-hide or nakatago nga lang, hindi siya nag-i-express ng ano ba talaga yung totoo nilang agreement. And makikita mo rin kay Article 1346 kung saan sinabi, which is obviously na rin naman talaga, yung absolute simulation or fictitious contract is void. Malamang kasi wala naman talagang intention yung both parties to enter into that contract. And then yung relative simulation, sabi, ang magiging epekto niya is that yung parties will be bound by the real and true agreement talaga. Except, eto nandito din, if it will prejudice a third person or if kung yung contract is intended which is contrary to law, morals, good customs, public policy, public order, yung mga ganon. So, if contrary it's dyan, hindi binding of course. Pero kung hindi naman, then that will bind or the party will be bind or bound to the true and real agreement talaga nila. Okay? So, let's take an example. Example ng absolute simulation of contract. So, halimbawa, if si Pogi and si Ganda enter into a marriage, pero yung marriage, alam natin, joke lang. Hindi naman nag-comply sa mga requirements to make that marriage valid kasi wala naman talaga silang intention to be bound at all. Okay? Wala lang, gusto lang nila ng trip. Trip lang nila yon. So, yan. That is simulation or absolute simulation. Another is if nag-execute sila ng deed of sale. Kunwari, nung sasakyan ni Pogi, pero yung deed of sale is, for paper, lang talaga, just to deceive the other persons. Pero, alam nilang dalawa na wala naman talagang, or hindi nila intention to enter into that contract of sale. Right? So, in that case, that contract is void. Obviously, yung marriage is void. Ito ding sa deed of sale, void rin. Kasi wala naman talaga. Hindi naman talaga binenta ni Pogi ang kanyang sasakyan kay Ganda. Now, example naman dito sa relative simulation. Ito is supposedly si Pogi gusto niyang i-donate or ibigay kay Ganda ang kanyang lupa, house and lot. Pero, ayaw niyang magbayad ng malaking donor's tax. So, ang ginawa nila, to avoid payment of donor's tax, they entered into a contract of sale. Nakita nyo, yung true intention is donation, pero yung ginawa nila, contract of sale. Pero if halimbawa ganito ang nangyari, ang totoo is that yung intention nila is mortgage. Gustong as a security for a loan ni Pogi kay Ganda, minortgage ni Pogi ang kaniyang lupa in favor of Ganda. However, yung in-execute nilang document is not of that for mortgage, okay? Kung hindi, deed of absolute sale. So, eto, relative simulation. Kasi yung intention was mortgage, pero yung nangyari or yung sa document nila ay deed of absolute sale. So, two acts involved, yung sa labas, sa tao or apparently, contract of sale, pero yung concealed or hidden, contract of mortgage. Now, as far as Pogi and Ganda are concerned, yung contract na in-enter nila is contract of mortgage. Pero as to third persons, 'di ba? Kasi contract of sale. So, I mean, deed of absolute sale yung in-enter nila. So, if consequently, etong si Ganda, the mortgagee, supposedly mortgagee lang sana talaga siya, but it was made to appear as, 'di ba, the buyer of the house and lot ni Pogi. And so, parang nangyari, they clothed here with the ownership and authority over that parcel of land. And so, this should not prejudice a third person if later on binenta ni Ganda ang kaniyang, I mean, ang lupa, ang parcel of land ni Pogi to Beauty. And which, kung wala ring alam si Beauty na mortgage lang naman talaga yung intention nun. Kasi, as far as Beauty is concerned, meron talaga siyang nakitang deed of absolute sale from Pogi to Ganda, right? So, Pogi and Ganda are now stopped from claiming na wala naman talagang deed of sale or, contract of sale na nangyari between them. Right? So, that's Article 12, 45, and 46. We are done with consent. In as much as gusto kong ipagpatuloy siya hanggang sa objects and sa cause and consideration, pero I think my voice also needs to rest. Kailangan na ata, humihingi na siya ng pahinga. So, we'll just have a part 2 of this discussion, and we will discuss objects and cause and consideration as another essential requisites for a contract. Okay, so that's it. See you in our next video. Thank you for watching.